The nation's highest court will have to address the most fundamental principle of law in its most important case ever, when it hears Najib Razak's final appeal from his conviction for abuse of power and misappropriation of 42 million ringgit of SRC International's funds. On June 7th, the former Prime Minister's solicitors signed off on a notice of motion asking the federal court to declare the entire High Court trial, in which he was convicted and sentenced, null and void, as well as for the case to be retried. Najib's legal team contends that he suffered a failure of natural justice, believing that trial judge Muhammad Nazlan Ghazali should have recused himself due to a conflict of interest. In an affidavit affirmed to support the application, Najib claims that Nazlan, who was Maybank's General Counsel and Company Secretary between July 2006 and April 2015, ought at least to have had constructive knowledge of what the defense argues was the true source of SRC's funds, which they say was central to issues in the case. The law imputes constructive knowledge of a matter to a person even if he does not have actual knowledge, if the matter could have become known to him through the exercise of reasonable care. According to Najib, the documents at the heart of the application only came to light in May this year, and as such, he was not in a position to raise this issue either at the High Court or the Court of Appeal previously. Ultimately, the Apex Court will have to consider whether Nazlan had knowledge of the matters as claimed by Najib and whether such knowledge made him a potential witness in the case. The Federal Court will also have to consider whether there was any real danger of bias in Nazlan presiding over the trial.